Thank you, Terrell, for that. And the judge in the case of the Parkland school shooter hearing arguments about both sides today about the use of victim impact statements.
It comes as the court determines what items will be used when Nicholas Cruz enters the sentencing phase in January. Local 10's Christina Vasquez has been right there in the courtroom for all the proceedings. She's live in Fort Lauderdale to break down what this all means. Christina.
There were several defense motions up for consideration. The judge heard arguments from both sides. In some cases, she ruled right from the bench, but she did defer ruling on one of them. Take a look. As the Parkland shooting case nears the start of its penalty phase, Nicholas Cruz's defense team filed several motions seeking to put limits on victim impact statements.
Relief because an overly emotional display during presentation of victim impact statements will deprive him of a fair trial before an impartial jury under Article 1, Section 22 of the Florida Constitution and the Sixth Amendment of the United States Constitution and due process.
In this one, the defense wanted the statements read by a neutral party to mitigate against emotion, adding in its motion, quote, an emotional display during presentation of victim impact statements will deprive Mr. Cruz of a fair trial. The state told the judge victims have a right to be heard.
What the defendant is seeking is that the victims in this case be neutralized.
The judge denied the defense motion and this one, asking the court to instruct the families of the victims and others present in the gallery to limit their emotions during victim impact statements or to excuse themselves from the courtroom if necessary. The judge said, like in any other case, if emotions are running high, she will weigh in real time.
I will remind all people in the courtroom to please maintain proper decorum.
When it came to this defense request to video record victim impact statements, the judge said she will take what both sides had to say today under advisement. You will first hear from the public defender and then the prosecutor.
A written transcript does not accurately reflect the highly emotional and often prejudicial manner in which this type of evidence is delivered to the jury. The state still maintains, Your Honor, that it will have a traumatic effect on these victims. These are not professional witnesses. These are mothers. These are fathers, these are spouses, these are children.
And once again, when it came to that motion, the judge saying she's going to defer her ruling. Meantime, separately, she did issue a formal written order denying a defense motion to suppress. This was related to evidence collected to search warrants. That was a hearing we brought to you back in November 15th. You can read that on our website. That's local10.com. Meantime, the next court hearing related to these pretrial motions is scheduled for December 29th. For now, reporting live for you in Fort Lauderdale, I'm Christina Vasquez, Local 10 News.
Christina,